do something, you need to make sure that you do it quickly. Obviously, not everything is a fire drill. It needs to be done instantaneously, but things should generally be done sooner than later. One of the other things, too, that can greatly add value to university applications under the new system is just to make sure that invention disclosures, we get the most out of them as we can. Like I said, the typical situation is to have a manuscript that's a very detailed description of the work that was actually performed in the laboratory by the inventors. To the extent that the inventors can enhance that description in the disclosure document, more importantly, to describe alternatives to their invention and ranges for different components of things they used in their work, that type of description is really invaluable in terms of your ability to rely on it later on and actually get more claim scope, get more value out of essentially a bare application that's filed without necessarily having a lot of input from an attorney. So to the extent that that kind of information can become available at the very beginning of the process, that will really improve the quality and the value of a patent application that's filed without necessarily having a lot of input on the part of an attorney. Okay. And again, going toward the idea of filing these applications sooner than later, I think it will take a commitment on the part of the university to just say we're going to file more applications sooner. But it can also be this idea that if something is identified as having any potential value, it's probably worth filing a very low-cost application without necessarily having done a lot of evaluation. Now, what that does essentially is it buys you some time to do a more in-depth review of the technology. And there's not a lot of downside to that because you do get some value out of these low-cost applications. There is some deterrent effect to filing them in terms of keeping others from trying to either publish on the invention or file their own application. And at the same time, if you decide in a few months that it's not worth it to pursue the invention further, well, you haven't really lost a lot. On the other hand, if you do decide to pursue the application more, you can file another application in this series maybe a month or two later on, and you haven't necessarily lost your rights because you've preserved at least something with that initial filing. Kind of a large overhead view of what does this do to the patent system. I think probably issued patents are actually more valuable, more defensible. There are more hurdles to actually get over to actually get a patent, so there should be fewer challenges after the fact in terms of people claiming to be inventors or prior inventors or some prior art which maybe wasn't identified but now is showing up as potentially invalidating the patent. To the extent that you do find new things, there are more tools to cure problems in issued patents. So, again, I think that patents, if they're issued, are less subject to uncertainty in terms of what they cover and whether or not they're actually valid. On the other hand, of course, what this could mean is that applications that are pending might be a little bit more risky in terms of an investment, just because you don't necessarily know whether or not they're going to be make it through the patent system without all these additional challenges or all this additional prior art that could be used against them. So, and again, that's just a prediction or possible scenario. I don't know that any of these things will actually be true, but that's something that you could see coming out of this new system that's being created. Right. Go ahead. Right. So that's all. I'll stop there, and I'm happy to take questions on anything I've talked about today, or also anything about patents in general. Yes.
Is this going to affect any provisional filing or not?
Yes. Yes, it will. The incentive should be to file more provisional applications.
Oh.
Okay. Now, if you're going to be filing more, there's the possibility that the quality of those applications will go down, just because if you're going to file twice as many applications, but you have the same budget for filing, well, you're probably going to be spending less time in writing a comprehensive application. Now, the best course is to file as complete an application as you can, as early as you can. But given the reality and the new laws, I think that people will be filing more provisional applications with a lower degree of disclosure in them. So
one question that comes out, and maybe you can be close to the mic. One student asked over here, are universities the only entities receiving filing discount?
Yes, basically the university microentity discount applies really only to universities or to individuals who happen to be solo type inventors with limited incomes. There's an existing discount for what's called a small entity, and that hasn't changed, and that's for small companies under a certain size. I'd have to check that size limitation, but maybe on the order of a few hundred employees or less. So small companies do get an existing discount from the Patent Office, and that is still in effect.
There is another question, and it's basically saying that, maybe let me read it what is here. The third-party system looked interesting. Do you expect to see it used often, since recently many in the tech industry have been in an uproar that ever basically get passed? So do you think that the third-party system do you expect it to be used more often than?
Yes. Yes. Yeah, the answer is yes. I do expect the third-party system to be used more often, and not necessarily for the patents that are involved in the university setting. That may not be the type of situation where it does get used, but certainly it's an avenue for competitors to challenge each other's patents as they come out without having to actually be involved in a costly litigation suit. So that is certainly something that I would expect tight market competitors to be involved in. Also, people who may be involved in some various tech industries and happen to feel that certain patents that get issued are essentially not new, not novel, not obvious, but for whatever reason the Patent Office can't find the right prior art when it looks for that and does its examination. If there are independent groups who want to who monitor these types of applications as they go through the patent process, a large part of this process is open to public inspection while it's actually going on, and there would certainly be an avenue there for people to cite information to the Patent Office in a way that essentially is not expensive and will make sure that the Patent Office has that information. So I think what this question is referring to is the idea that currently there are a lot of tech-related patents where they might be software, or they might be method-type patents where you read the patent and it seems like, well, this is either obvious or it's already been done, but I don't know that and I can't prove it because I don't have a reference that I can give to a patent examiner to prove it, right? And so the patent gets issued because the examiner can't find anything, but many people feel that it's not new and it's not deserving of a patent. Well, if they know of information that they can provide to the Patent Office that demonstrates that it's already been done before, then that will prevent those types of patents from actually issuing from the Patent Office. So, yeah, I think people will use that, not necessarily with the patents that I work with.
Here's another good one. I think that this basically talks about the overall time that it takes to